Hi, I'm Wong. Good day to you. Today there is a case at our law firm that I need to convey to you. Our client is called Phoebe, a property manager employed by Home Counties Property Management Limited, called HCPM, for 7 years. Now she faces a situation regarding her employer's refusal to accommodate her request for flexible working hours following maternity leave. Depend on her situation, we have to identify the potential claims she may bring against her employer and provides our advice on remedies and the next steps Phoebe can take. Now, let me tell you the ins and outs of the case. Phoebe's job entails full-time work, including visiting property, coordinating repairs, and liaising with clients and contractors. She went on maternity leave in October 2024 and has requested to work 3 days per week upon returning, citing childcare responsibilities. A colleague of Phoebe has expressed interest in covering the remaining 2 days of her. However, the employer, HCPM, refused her request, asserting that all property managers must work full-time to provide comprehensive client services. Her appeal was also rejected by the employer, HCPM. Now, in my opinion, Phoebe's situation is related to these laws and regulations, including the Equality Act 2010, Employment Rights Act 1996, and the Maternity and Parental Leave Regulations 1999. Okay, first, the Equality Act protects individuals from discrimination based on the protected characteristics, including sex. There are two key provisions we can consider for our clients. There are two types of discrimination, which are direct discrimination and indirect discrimination. Phoebe's situation seems to be considered as indirect discriminations. An indirect discrimination occurs when an employer's provisions, criterion, or practice disproportionately disadvantages individuals with a protected characteristics. In the case on the facts, Phoebe's characteristics is a woman with childcare responsibilities. The employer HCPM must demonstrate that requiring property managers to work full-time is a proportionate means of achieving a legitimate aim. Now, there are two questions we have to look at. Now the question is, was the refusal of the employment HCPM is discriminatory? The requirement for full-time work may indirectly discriminate against women. The statistical evidence supports that women are more likely to be primary caregivers of the children. Employment must justify the full-time work policy as proportionate and necessary to meet business needs. Failure to do so may render the refusal unlawful under the Equality Act 2010. The second question is, was the request handled properly by HCPM? Under the law, Phoebe's request should have been reasonably considered. The refusal letter should outline specific reasons, and her appeal should have been assessed impartially. Procedural deficiencies can strengthen her claim. The second legal issue we have to look at is that under Employment Rights Act 1996, there's a right, namely right to request flexible working under sections 80 F to G. Hence, Phoebe has the statutory right to request flexible working if she has at least 26 weeks of continuous service. The employers must consider requests reasonably and respond within 3 months with valid. And once they want to refuse the application by the employee, they have to expand the business-related reasons for the refusal. For example, increased costs or detrimental impact on quality or performance of the work. For the procedural compliance, the employer's decision-making process must align with the statutory requirements also. Now we look at the final legal issue, which is Maternity and Parental Leave Regulation 1999. There's a right under the regulation which called right to return to work. After maternity leave, Phoebe is entitled to return to the same or comparable job on no less favorable terms. There's a protection called protection from detriment, which means adverse treatment due to maternity leave is unlawful under these regulations. Okay, now I found a case, namely British Airways PLC against Starmer, which occurred in 2005. This is a landmark case. The case is similar to Phoebe case also. Captain Starmer, a female pilot, requested part-time work to accommodate childcare responsibilities. The British Airways refused it, citing operational challenges. Okay, finally, the tribunal found in favor of Starmer and ruling that the refusal amounted to indirect sex discrimination. The employer, British Airways, failed to demonstrate that its full-time work requirement was a proportionate means of achieving its legitimate end. Okay, this case is relevant to Phoebe because the case is similar. Phoebe's request for part-time work was refused on operational grounds. HCPM must prove that the full-time requirements is essential and proportionate. If failing to do so, which Phoebe could claim indirect sex discrimination. In my opinion, Phoebe does not affect their work progress and efficiency because her colleagues have volunteered to make up the 2 days of work of her, right? And there are many property managers in the company also. So I think this is not the problem. My advice to Phoebe is try to claim indirect discriminations. Phoebe can argue that the full-time requirement disproportionately affects her as a woman with childcare responsibilities. The burden shifts to HCPM to justify this requirement. If failing to handle flexible working requests by HCPM, like HCPM failed to reasonably consider her request or provide adequate justification, this may constitute a breach of the law also. Now, there are several steps that Phoebe can take. First, Phoebe should lodge a formal complaint highlighting procedural shortcomings and potential discriminations. Second, if the grievance is unresolved, she could request mediation to resolve the dispute amicably. Third, if should mediation fail, Phoebe has the right to file a claim within 3 months of the employer's final decision. Now we look at the several remedies available to Phoebe if she can claim the rights successfully. If the employment tribunal may issue a declaration that HCPM's actions were discriminatory to Phoebe, there are several compensations entitled to her. First, she can claim for the injury to feelings. The compensation is calculated using the vendor bands. There are three bands. For the lower band, which is for less serious cases, £1,200 to £11,700. For the middle band, which is for the moderate cases, the compensation is about £11,700 to £35,200. For the upper band is for the most severe cases, the compensation amount is £35,200 to £58,700. Phoebe case is simply considered as middle bands. If the inability to work part-time results in financial hardship, she may claim for this also. Lastly, Phoebe can apply for reconsideration for flexible working request. The tribunal may direct HCPM to reconsider her request and explore feasible alternatives such as job sharing. Okay, that's all for today. Thank you. Bye bye.